Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Several people sent me this story, and it's a follow-up to a previous story I did. I'll put a link to the previous video below because it's been a little while. But I told the story not too long ago about the guy who wanted to go moose hunting in Alaska by hovercraft. Now, as I'm sure you're aware, it was all the rage a few years ago to go moose hunting by hovercraft. It's something we've all wanted to do. And apparently, there are people in Alaska in positions of power who thought it was inappropriate for this man to go moose hunting by hovercraft. And so they attempted to stop him from doing that. And he didn't think that was right. So he took his fight all the way to the U.S. Supreme Court, which is something we've all wanted to do. And we've heard people say it. I will fight this all the way to the U.S. Supreme Court. In fact, when I was fighting my parking tickets in Pontiac, I probably said such a thing to somebody at one point or another, going, if I have to, I'll take this to the U.S. Supreme Court, knowing full well it would never go that far. But as several people sent me a story, including Josh, thank you very much, taking a case to the U.S. Supreme Court sounds like a lot of fun, but it turns out it's ghastly expensive. I mean, it's going to cost you more money than you have, most likely. So the headline, this is from the Washington Post, but widely reported elsewhere because many people picked the story up. Robert Barnes wrote the article. The Alaskan moose hunter beat the odds at the Supreme Court, and it cost him $1.5 million. A $1.5 million legal bill for taking his case to the U.S. Supreme Court. Now, it's a long and winding road to get there, but here's how it went down. Moose hunter John Sturgeon, a man who's named after an ancient fish, serves as both inspiration and warning for anyone who's ever gotten worked up over perceived injustice and vowed to fight it all the way to the U.S. Supreme Court. He's an inspiration because he took on the federal government and twice beat the odds. But he's also a warning because his 12-year battle to travel on a forbidden hovercraft through a national parkland to his favorite hunting spot cost him in excess of $1.5 million. He said, I had no idea how much it was going to cost, but you start down this slide and there's no stopping it. Not many people could do what I did because they don't have the financial resources, which I don't either. But I did have a cause that really ignited people. And ironically, it has nothing to do with moose hunting or hovercraft. That's just what makes the story interesting in terms of entertainment value. This is really more about just the idea of who controls what you can do where, in particular with government land, because government parks, they're not owned by the government in the sense that you or I own a piece of property, okay? I own a piece of property. I can go out on it and do things on it. But the government holds things, in essence, in trust for us, the taxpayers, because the government isn't the occupier of the land. They're just who we put there to take care of the land. So when they tell somebody they can't do something on this particular piece of land, they need to have a pretty good reason for doing that. So Sturgeon agreed to let the Washington Post see his legal bills and go over the costs and financing of it just to get a better understanding of what it costs to take a case to the Supreme Court. So he got donations from a lot of people, including the Alaska Wildlife and Conservation Fund, the NRA, the Alaska Conservative Trust, national and international hunting groups, hundreds of ordinary Alaskans, and then, of course, one very wealthy one. Edward Rasmussen read about Sturgeon's case, called him up and found him sincere, and then said, hey, I'll give you some money. I'm fortunate, I'm wealthy, I can afford it. So he gave him maybe a couple $100,000 towards his legal fees. The money covered things such as the $20,000 bill to print the legal documents exactly as the Supreme Court requires. And that's the crazy part. Filing documents with courts have guidelines, and they say you must file these kinds of things. And so in Michigan, you've got to file your legal pleadings on 8.5 by 11 white paper. I mean, that's not that crazy of a concept. That's the common most type of paper. But if you've ever seen things filed with the Supreme Court or opinions issued by them, the first thing you notice is they're formatted very oddly. They've got huge margins all the way around, for instance. And they use a different font, typeface, things like that. So the idea that it costs $20,000 just to print the documents shows you how insane this can get. Sturgeon's lawyers ran up $11,000 in hotel bills. And they were also doing things like practicing their arguments in moot courts in Washington. There were over 3,000 hours of legal work put in at the law firms that have represented him. By the way, this case goes back to 2011. 7 or 8 years of legal wrangling to get this ruling. At the end of the summer, Sturgeon's supporters boarded a sternwheeler for a trip down the Chena River for a fundraiser billed as the Thanks a Million Victory Cruise. There were drinks and dinner, tributes to Sturgeon, and a silent auction offering uniquely Alaskan items such as a gold nugget, several fur pelts, and other things. Somebody who donated said, "Hope this helps. Thank you for taking the fight to the feds." Governor Mike Dunleavy was on board to call Sturgeon a hero and to submit the winning bid for one of the pelts that was donated as an auction item. To show how broad the support for Sturgeon is, also along were several prominent Alaskans who had signed a petition to remove Dunleavy from office, Dunleavy being the governor. Sturgeon's case resonated because it could bring along sought clarification of the Alaska National Interest Lands Conservation Act, or ANILCA, with which Congress set aside more than 100 million acres for preservation. Alaskans have argued that Congress did not intend for the land to be regulated like other federal parkland and preserves because the way of life is so different in the last frontier being in capitals, because, of course, I think that's what is on Alaskans' license plates and also is one of the things that they consider themselves, and I salute them for doing that. Sturgeon said he only knew that he didn't think national park rangers had the authority to tell him he could not use the hovercraft as he had for years. I called the state of Alaska and said, "Aren't you supposed to manage the state's rivers?" And they said yes. That's when I kind of decided I wanted to maybe, sue the federal government. But I didn't want it to be frivolous. And don't think this is as simple as some people might want it to be. There are often conflicting jurisdictions on the same piece of land. And a lot of these conflicts are not clear to resolve. And it's scary that it's going to cost you $1.5 million to get it resolved. But you've got the state of Alaska, then you've got a federal preserve, and then you've got rivers flowing through it. And the question is, who governs what? And there are rules on this, and some of them are quite clear and some of them are not. And by the way, the lack of clarity is not Sturgeon's fault. The lack of clarity comes from the fact that Congress passed a law to create this ANILCA, but didn't lay out exactly how the other laws were going to interplay with it. He went to an Anchorage lawyer named Doug Pope and laid out his problem. Pope did some research and came back with what he said is good news and bad news. He said, good news, you've got a good case. Bad news is it could go all the way to the Supreme Court and cost you maybe $700,000. And you'll notice that estimate was off by about 100%, a little more. Pope advised instead spend the money on your grandkids. By the time this is done, are you even still going to be moose hunting? That's an ominous thought. Turns out he is still moose hunting, and his grandkids will be just fine. The origins of Sturgeon's case have been told now in 2 Supreme Court decisions. In the fall of 2007, he was trying to fix a steering cable on his hovercraft, beached on a gravel shoal of the Nation River, within the Yukon-Charlie Rivers National Preserve. For years, he had hovercrafted to get across the shallow rivers to his favorite hunting spot near the Canadian border. On this day, he was approached by national park rangers who informed him that the craft was banned in the federal park. Not only was he barred from using it, he was told he could not use it to get home. He was forced to drag it home, and by then, of course, he was fired up enough to file the lawsuit. He's a businessman, and he also used to be an Alaska state forester. So, he knows a little bit about this stuff. The lawyer, Pope, believed the only place Sturgeon could win was at the Supreme Court because there were bad precedents set in the Ninth Court of Appeals. So, Pope once before had taken a case to the Supreme Court. It lasted 10 years, and he wasn't ready to do that again, so he provided legal advice through the process, but another Anchorage law firm, Ashburn and Mason, became the primary lawyers, and the firm threw everything into it, said lawyer Matthew Findlay. There was, of course, the first trip to the district court, which they planned on. I guess they didn't plan on losing, but they anticipated they might lose. Cost them almost $150,000 just to go there. And then the appeal to the Ninth Circuit, which cost $82,000, where he lost. And then Sturgeon acknowledges he's about to give up at that point, knowing the odds of getting a case accepted at the Supreme Court range from about 1% to 3%. And that's the other thing I tell people. This is also true in the state of Michigan, and many states are like this. That if you take a case up and you lose on appeal, meaning that your last or your next best thing is the Supreme Court, whether it's the state Supreme Court or the U.S. Supreme Court. Hundreds and hundreds and hundreds of applications for leave to appeal are submitted on behalf of people who want their cases heard. And in Michigan, the rate, last time I saw it, was 3 out of 100 cases they accepted. They get 100 applications, they'd pick through and they'd find 3. And of the 3, 2 were criminal cases, 1 was civil. So meaning that, generally speaking, if you have a civil claim that you want the Michigan Supreme Court to hear, very, very slim odds of getting that heard. And I don't know if there's a breakdown between criminal and civil at the SCOTUS, but there might be. But 3 out of 100, and that again is roughly what they have in the state of Michigan. Different states might vary, but that means that, like I said, 100 people go through all the trouble of getting there. 97 litigants are told, we're not going to hear your case. The Ninth Circuit's decision about the federal government's power managed to unite usual foes. The Alaska Outdoor Council, representing hunters, urged him to go on, as did the Alaska Native Corporations, which represent natives and their right to subsistence fishing and hunting. And those two are not always on the same side. Alaska Outdoor Council is at this end of the spectrum, and the Native Corporations are this end of the spectrum. But they each gave $30,000 to the fight, and that's what got me to the Supreme Court the first time, Sturgeon said. He spent about $10,000 to bring his whole family for oral arguments in January of 2016. The grandkids recouped a little by shoveling walks on the Capitol Hill block where they rented a house for the hearing. Industrious kids. 3 months later, the Supreme Court ruled for Sturgeon. Chief Justice John Roberts said the Ninth Circuit judges had gone down the wrong path in their analysis and ignored vital issues of state sovereignty on the one hand and federal authority on the other. So all that ruling, though, meant for Sturgeon was that he got another chance at the Ninth Circuit. So at this point, his legal bill is about $700,000. So the attorney who guessed that that would be the amount was correct for one trip to the Supreme Court. Sturgeon's a low-key 73-year-old guy, and he tells matter-of-factly about killing a bear that tried to invade his hunting cabin. Most people panic and freak out, but, that's part of the job of living out in the woods. I don't mean that he lives out there, but he was spending time out there. Sturgeon's traveled the state of Alaska talking about his case and is now well known enough that the governor wonders if he has a political career in mind, although he says he does not. His lawyer, Findley, says people react to Sturgeon's authenticity. I had a lot of friends on the left saying, "Oh, what are you doing taking this federal overreach case?" Findley said. And then they meet John, and they say he's one of the classiest, nicest people they've ever met. I think his personality came through in the suit. He was asking to restore balance. That's a theme we had. It's a way more complicated than that. We're just fighting the federal government. His supporters are a bit more fiery. So Sturgeon's second trip to the Ninth Circuit, which cost $56,000 in legal fees and costs, yielded another loss. But by then, there was no question that he's going back to the Supreme Court a second time. How many people can say that they've been to the Supreme Court twice? I mean, I know some people can, but trust me, it's a minority. Rasmussen, a former president of the National Bank of Alaska and a former University of Alaska regent with the Family Foundation well known in the state, was game. I found over the years, if you have the money and you have the willpower and you have good legal advice, you can usually beat the bastards, Rasmussen said. The Supreme Court was game too, accepting Sturgeon's petition, which cost $155,000 in legal fees and costs, and they agreed to review the second Ninth Circuit opinion. Oral argument is November 6th of 2018, and on March 26th of this year, the court overturned the appeals court and ruled for Sturgeon a second time. Congress intended for Alaska to be treated differently. Justice Elena Kagan wrote for the unanimous court, and some rules that apply elsewhere do not apply there. She noted the court was not disturbing lower court decisions on subsistence fishing and hunting for Alaskan natives. For that reason, park rangers cannot enforce the service's hovercraft rule on the Nation River, Kagan wrote, and John Sturgeon can once again drive his hovercraft up that river to Moose Meadows. which sounds like a nice place if you're a moose, but apparently there's a sturgeon shooting at you. At the fundraiser cruise, Sturgeon told the crowd his own lawyers couldn't have written the court's decision any better. It reads like a book, and Justice Kagan did a really good job. She's a kind of liberal member of the court, he points out, but again, it was unanimous. He got them all. All of them voted for him. As the guests disembarked, many ignored the light rain to pose for pictures with Sturgeon's hovercraft, which is in the parking lot. It's been refurbished and renamed to honor the unanimous rulings. It is now the 9-0. You got your Hawaii 5-0, got your Alaska 9-0. So my hat's off to Mr. Sturgeon, not the least of which because he went to the Supreme Court twice and won, but also because of the fact that he lets me come out here and crack jokes about hunting for moose by hovercraft. So, like I said, I'll put the link to the original video below. It's a little complicated, and it's kind of a strange story, but it's a good one, and it scares people, and it scares me too. And what it scares me by is how expensive this stuff is. And so that's, it shouldn't be that way, but I'm not sure how to fix it. So once in a while, you just point out the problems and worry about the fixes later. But, I doubt that back in the early 1800s that it cost the equivalent of this much money to get a case heard by the Supreme Court. And so when you make it that it costs millions of dollars to take a case successfully to the Supreme Court of the United States, then you understand that the old saying about the courthouse doors being open for everyone, it's not true. It's not true. You couldn't afford to go there, so it's a scary proposition. But it's a great story, and it's well illustrated by the article out of the Washington Post written by Robert Barnes and pointed out to me by Josh and several other people. Dan also, thank you very much. An Alaskan moose hunter beat the odds at the Supreme Court, and it only cost him $1.5 million. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.